Delivery of judgment. Item number 48.
For reasons to be mentioned in the judgment, this appeal is dismissed.
May I please your lordship? With the consent of the other side, my lord, item number 9 and 10, my lord. These two matters may come up, my lord, because we have already filed objections, my lord. They are in process of filing. Let those objections come up in the record, my lord. And matter may be taken up maybe on Monday.
Tomorrow, my lord, tomorrow, so urgency is.
Monday will be better,
No. They are appearing on caveat lodge.
because I have received the brief yesterday, my lord.
So what? There is a caveat.
So I need, so already objections are being in the.
We have already
Fine.
talked, when the consent is.
You are caveator, you are caveator,
They are the caveator.
or you are caveator.
And yesterday we consented only on the subject to condition that tomorrow the matter will be.
Okay, tomorrow.
Okay, tomorrow.
Heard Mr. B. Datto. Learned senior.
He is in item number 10, I am in 9.
Heard Mr. S. Deka. Learned, you are not in 9.
Not in. No, not in
Okay.
9. Two set of appeal.
Heard learned counsel for both sides. Learned counsel for the caveator, Mr. D.K. Bagchi, has submitted that he has filed written objection in
In both the.
both the separate order in written objection, which is not tagged with the record. Hence, he prays for placing the written objection filed by the caveator on record. Registry to do so and list the matter again tomorrow.
Grateful, my
That
Matter
is
may be
nine.
taken up in the second half, my lord. Some time will be required.
No, what?
Let us
Yeah,
see,
yeah,
let us see.
Yes,
Let us see, my lord. Let us.
Where he is, my lord.
May I please your lordship, with the consent of the other side, I beg to mention 18, item number 18, my lord. It may become next week, my lord. Mr. B. Chaudhary is out of station, my lord.
Heard Mr. What is your name?
Hey, Hassan,
F.A. Hassan,
We
learned
have-
counsel, submitting on behalf of Mr. B. Chaudhary, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. He has submitted that he has informed learned counsel for the other side, who does not have any objection regarding his prayer. List this matter on 6th of March.
May I please, Lordship? Lordship, I am praying for listing the in order column, my lord, in MSc appeal, my lord.
When?
Any date, my lord.
6th of March.
Oh, bless me.
May it please your lordship, item number 32, my lord. With the consent of my learned friend, my lord. The matter may be 32.
32.
Some difficulties today, my lord. It will come after
10th of March, lordship, if possible, it will be convenient for us, after 10th of March.
Heard me, Mr. V.K. Borua, learned counsel for respondent number 1 and 2, who prays for an adjournment on the ground of some personal difficulties. Mr. S.P. Sharma, learned counsel for the appellant, does not oppose the prayer, hence the prayer is allowed. Let this matter be listed
10 March episode.
11th of March.
on 11th of March.
Hello, my lord.
May I please your lordship? Lordship, I beg to mention item number 22. Matter has been enforced to us, lordship. So I'm not pressing this RFA, lordship.
What is your name?
P. Sharma.
Heard Mr. P. Sharma, learned counsel for the appellant, who submits that this appeal has become infructuous and therefore the appellant is not intending to pursue the same. Stop. Considering the submissions made by learned counsel for the appellant, this appeal is dismissed on becoming infructuous.
May I please your lordship?
The IO dispose of all.
May I please your lordship? I beg to mention item number 30 of today's list, lordship. In this matter, I have some personal difficulties with this. So
Lordship, I cannot take up the matter today.
Heard Mr.
PP Bothakur.
You are for appellant.
Yes,
Heard Mr. PP Bothakur, learned counsel for the appellant. You have informed the other side.
notice not issued yet.
Okay. Who seeks an adjournment on the ground of some personal difficulty. The prayer is allowed. Let this matter be listed on 6th of March,
Next week, second week of April.
30 March.
Yeah, please, your lordship. Lordship, I beg to mention item number 20, lordship, on behalf of the appellant, lordship. In this case, on last occasion, directed us to take steps upon the respondent number 1 by paper publication, lordship. Some more time is required to take paper publication steps, lordship.
Item number?
22-0 on behalf of Mr. U. Datta, lordship.
You are Mr.
ABT Hotel.
F.
ABT Hotel.
Yeah, sorry, Mr. ABT Haq, learned counsel for the appellant. Who you have informed the other side.
Well, I will inform lordship. We have tried to contact lordship. They are coming.
Who submits that the appellant was directed by this court to take steps for publication of for issuance of notice by way of publication of the same in newspapers. On respondent number?
Up one, lordship.
On respondent number 1. He submits that due to some difficulty, the appellant could not take steps and seeks some more time. The prayer is allowed. Let this matter be listed. ECMA. 27th of March. The date of notice to be given in the date of appearance to be given in the notice to be published in the newspaper shall be 30 March. List accordingly.
May I please, your lordship? Your lordship, there's an urgent listing of FAO along with IA tomorrow, your lordship.
What is the urgency?
Your lordship, during the pendency of the title appeal, the opposite party had tried to illegally construct a boundary fencing with iron sheet over the suit land. Now,
It is pending.
appeal is pending, your lordship.
Okay.
And the honorable district judge has refused to grant any injunction, so that's why we are preferring that way.
Tomorrow.
Much older.
Your lordship, I beg to mention item number 29 of the daily list. Your lordship, 10,000 condonation fee was supposed to be paid and the same shall be deposited within this week. Your lordship, kindly the date may be given after 1 week, your lordship.
Who is the other side?
Um,
You are for the appellant.
Yes, your lordship. On behalf of MSG Bora.
Have you informed the other side?
Your lordship, senior counsel had called the engaged counsel for the opposite party regarding the same, but then they did not receive their call, your lordship. So they will be informed.
Then you wait for your turn.
Okay.
When the matter is called, we will allow your prayer, but you have to wait.
Pleasure, your lordship.
May I please, your lordship? Your lordship, I am praying for listing of 2 MSc appeal. One appeal has not been listed since last 4 years.
In hearing column, For
It will not
hearing.
come in hearing. It will come in
Order.
referral to mediation. No case will come in hearing directly. It will first come for referral, then,
why?
no, the system has been made like this.
No, you are wrong. Only those cases where there is a possibility of amicable
No,
settlement.
no. First time it has to come for referral. If during that time, if both the parties doesn't agree, then it will go for hearing or other orders.
No, on what basis you are saying so?
That has been informed by the registry.
No. It will come. Is there any possibility of amicable settlement?
In these 2 cases, no.
Then in orders column it will come.
Yes.
And date at the due. 6th of March. Give mention memo.
6th of March. Obliged.
May I please, Your Lordship? First, I beg to mention 2 matter for listing orders column, Your Lordship. Any date first week of.
What matter?
MSc appeal, Your Lordship.
6th of March.
I'm so obliged.
My lords, may I kindly mention MFA 941 of 2025, MFA 103 of 2023, and IA Civil 1908 of 2024. My lord, the decree has been passed. The matter has been.
And what is your prayer?
My lords, my prayer is the matter should be listed early because the appeal has become infectious because the decree has been fulfilled by the railway authority. We have received the money and there is nothing which has to be paid by the railway.
Okay, in our orders column? No, next week. Twenty-sixth February.
Grateful, George. Great.
You give mention memo.
For refer to the special mediation, item number 1.
Please, your lordship.
Yes, is there any hope?
Some law point has to be decided, so it cannot
Case
be.
is not fit for mediation.
Why?
Because lordship, the deceased was a government employee. And as per notification dated 14/9/2017, the family member of the deceased will receive full salary till the date of superannuation. Lordship may fix the matter for hearing.
Then who is listing these matters for referral? Why registry is listing?
Lordship, the registry.
Joint registrar of Mati. Chinmaguru, Etapandu, Chimara.
Your lordship, in this case.
Heard
neither-
Mr. S. Sharma, learned counsel for the appellant. Also heard Mr. D. Mondol, learned counsel for the respondent number 3.
1 to 3.
1 to 3. Though this matter has been listed for referral to special mediation drive -- mediation for nation. However, learned counsel for both sides have submitted that this appeal involves question of law to be decided by the court after full adjudication, and it is not a fit case which may be referred for mediation. Accordingly, this matter is not referred to mediation. It is, what is the stage?
The service is complete and LCR has also been received.
Release this matter for hearing
Your lordship,
after 4 weeks.
your
Not,
lordship,
no
in the second week of April or last week of
after
April.
6 weeks.
After 6 weeks, then it.
On the, if it does not get listed, you make mention.
Obliged.
Petition, item 2.
May I please, your lordship? Well, petitioner want to withdraw the appeal, my lord.
What is your name?
N. Burwa.
Heard Mr. N. Burwa, learned counsel for the appellants, who submits that the appellant does not want to pursue this matter. Appellants do not want to pursue this matter and may be allowed to withdraw the appeal. The prayer is allowed. This appeal is dismissed on withdrawal.
Hello,
Item 3. Item number 3.
None has appeared for the appellant when the matter was called. Let this matter be listed on
6th of March.
6th of March.
Item 4.
Heard Mr. S. Islam, learned counsel for the appellant. Also heard Mr.
PM Talukdar Lord.
P.
M Talukdar Lord.
P. M. Talukdar,
For
appearing
respondent
for
The insurance company Lord.
respondent number
2 Lord.
2. This appeal under section 173 of the MB Act, 1988, has been preferred by the appellant slash claimant, impugning the judgment. Your claim was dismissed,
Dismiss it.
including impugning the judgment dated 22/9/2022, passed by the Motor Accident Claims Tribunal, Barpeta, in MAC case number 415/2020, whereby the claim petition filed by the present appellant was dismissed. Stop. The appeal is admitted. Issue notice to the respondents and call for the records of the MAC case number 415/2020 from the concerned tribunal. Since Mr. Talukdar has appeared for respondent number 2, no formal notice need to be issued to the respondent number 2. You have received the memo of appeal.
Yes, Lordship. Lordship, there's a request. My name has not been reflected. Earlier also in the IA, the same order was that it's still.
However, the appellant shall take steps for issuance of notice upon respondent number 1 by speed post as well as by usual mode within 7 days of date of this order, returnable on 2nd of April. Name of Mr.
PM Talukdar.
P.M. Talukdar be reflected in the cause list as the engaged counsel for respondent number 2 henceforth. List accordingly.
May I please be with Lordship, item number 3, just Lordship, I missed.
So what should I do?
Let me kindly be.
Item number
3, Lordship.
3 dio. Why you missed?
No, I just coming other court, Lordship. There was a.
Heard Mr. A.R. Agarwala,
If I announcement.
learned counsel for the appellant. This appeal under section 173 of Motor Vehicle Act 1988 has been preferred by the appellant Balaram Nath alias Balaram Nath, impugning the judgment and award dated 30/9/2022 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MAC case number 1758/2017. The appellant is aggrieved mainly with the quantum of compensation awarded to him and has prayed for its enhancement. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 1st of April. This appeal is admitted. Let the records of MAC case number 1758/2017 be called for from the concerned Motor Accident Claims Tribunal. The registry to take steps for requisitioning the aforesaid record list accordingly.
Much obliged.
Item 5. Item number 5.
None appears when the matter was called. So place this matter again on 6th of March.
Item 6.
Heard Mr. K.K. Bhatto.
In this case, the vehicle involved in the accident was not insured with us. Accordingly, you adduce evidence to that effect, Lordship, that the vehicle was not insured with the Reliance Insurance Company. But liability was passed upon the.
Mr. K.K. Bhatto, learned counsel for the appellant. This appeal under section 173 of MV Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 2/2/2024, passed by the Motor Accident Claims Tribunal number 3 in MSC case number 1007/2018, whereby the appellant insurance company was directed to pay an amount of rupees 10,95,800 to the claimants with an interest of at the rate of 9% per annum from the date of filing of the claims case till realization. Stop. This appeal is admitted. Call for the records of MSC case number 1007/2018 from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps
See,
for
name of the respondent number 1 and 2 has been reflected.
then what? You have served notice?
Yes, yes, in case there was delay, a delay was gone on, at that time there was present.
No, but here note,
But their name is reflected in the cause list.
but notice have not been issued. Notice will go to them if they are not there.
That's-
Issue notice to the respondents. The appellant shall take steps for issuance of notice by registered post, by speed post, as well as by usual mode within 7 days from the date of this order, returnable on 1st of April, list accordingly.
I for the statements. I for statements.
Notice will go. You're ready to pay 50%?
No, sir. When we have no liability in this case.
Okay, then in IN issue notice.
Item 7.
This is statutory appeal. Matter was heard in detail on 6th January 2026 along with an application order 39 rule 1 and that is registered as IA 15 of 26. This honorable court also grant injunction order in my favor, but wrongly it is not admitted. Notice issued, I have also taken steps.
You have to taken steps.
Yes, sir.
Heard Mr. R. Ali, learned counsel for the appellant. Though it appears from order dated 6/1/2026 that though on that date notice were issued, how many respondents?
Total 7 respondents are there.
To the respondents. However, this appeal was not admitted. Hence, it also appears that on that day, interim injunction was granted in favor of the appellant in the connected interlocutory application. This appeal is admitted. Stop. On perusal of the office note, it appears that what affidavit you have filed? For taking steps. Taking steps.
24 hours I have to take steps.
Okay. On perusal of the office note dated 17/1/2026, it appears that notices issued to respondents have not yet returned. The registry is directed to place the postal track consignment report of the notices issued to respondents before this court on the next date fixed. Let this matter be listed when 6th of March.
In injunction was granted, that may be continued also. Still the apprehension is still there.
In interlocutory, I also heard Mr. R. Ali, learned counsel for the applicant. The notice issued to service report in respect of notice issued to respondents have not yet been received. The registry is directed to place the postal track consignment report of the notices issued to respondents by speed post before this court on the next date fixed. Let this matter be listed on 7th, 6th of March. The interim injunction granted on 6/1/2026 shall continue till next day.
Item A,
May I please, your lordship?
May I please, your lordship? Lordship, in this case, this is a statutory appeal under section 37, your lordship, of the Arbitration and Conciliation Act. I am before your lordship against an order which was passed on 30/11/21, whereby the arbitral award was set aside.
30/11/2021.
Yes. And it was totally set aside under section 34, your lordship. Your lordship was pleased to condemn the delay, and because of which it is listed, your lordship.
It's for admission at this.
We'll admit the appeal.
It's only, Milos, whether it calls for an admission or not, my lords will have to test that.
This is a
Because
statutory
this is a-
appeal, that is what I-
absolutely right. I'm not disputing, sir. I'm not disputing for a second. This is a classic case of order which is perverse. Because the documents taken at the back and all, I'll make good
No,
that.
but the question of perversity, we can decide after full hearing.
No problem, Milos. I leave it to my lord's discretion, totally. I leave it to my lord's discretion. Then Milos, if I admitting it, my lord, then may give me a chance to place everything on the record because they have not filed all the documents which was in
Some
the
records may be required to be called for.
call for, that's okay, Milos.
I think it will be before the arbitration, I think.
No, even the trial court has all the records.
Because I was not there in the earlier stages, so I'm totally, my learned colleague was there from the initial stage.
I have been appearing, Milos,
So
since
he will
day
be
one.
much aware about.
Yeah, no, so we can call for Milos or I may be given a
I think
limited
the
time to file
original
my
may call
response.
from Indian Council of Arbitration. Because the arbitration record, if I am not wrong, from the order, it appears that the records were sent back to the Indian Council of Arbitration. If your lord.
From where it has to be, whether calling of record would be necessary.
Only 34, the only trial court records, Milos.
Because they will be raising, I think, with regard to the statement of claims, what we had raised and what was the award passed, whether it was based upon the documents placed.
If you
before the-
allow me for 2 minutes.
Yeah.
So the scope of 37 is very limited. Therefore, my laws will not get into the reappreciation of the evidence or the merits. My laws will only follow the contours of 34 and whether the trial court was right in deciding and setting aside the award within the four corners of 34. So only 34 records.
So
are available.
we will call only trial court record.
That's similar, exactly, because that's the
From
scope
the-
under 37 minutes.
Heard Mr. A. Vishwas, learned counsel for the. This is
My
item.
name is not reflected. It may be reflected in the cause disclosure. The earlier counsels are reflected.
A. Vishwas, learned counsel for the appellant. What is your name?
Ajoy Roy Mills.
Also heard Mr. A. Roy, learned counsel for the respondent. This appeal under section 37 of the Arbitration and Conciliation Act 1996 has been filed by the appellant impugning the order dated 30/11/2021 passed in arbitration petition
1 of
number
2020.
1 of 2020 by the Court of London Additional District Judge
Number 2.
number 2, Aizawl Judicial District, Aizawl. Though there was a delay in filing the instant appeal, the said delay has already been condoned in the connected interlocutory application. Stop. This appeal is admitted. Let the records of
Arbitration petition
the
one.
arbitration petition number 1/2020 be called for from the from the Court of Learned Additional District Judge number 2 Aizawl Judicial District Aizawl. Stop. The registry shall take steps for requisitioning the aforesaid records. Since the respondent has been represented by their engaged counsel in this appeal, no formal notice need to be issued.
Very well. We have been appearing.
Stop. The respondent is allowed to file a written objection. You want to file some
Yes, Milas. I need, because at least minimum of
against the contentions raised by the appellant in this appeal on the next date fixed. List this matter 1st of April.
grateful.
Oblige, Your Lordship.
Item 11.
May I please, Your Lordship? This is the statutory appeal, Lordship. I have filed this RFA on Lordship against the judgment and decree passed by the Learned Civil Judge Senior Division 1 on 15/10/25, Lordship.
Heard, Mr. What is your name?
P. Sharma, Lordship.
Heard, Mr. P. Sharma, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure, 1908 has been filed by the appellant Sandeep Agarwala, impugning the judgment and decree dated 15/10/2025 passed by the Court of Learned Civil Judge Senior Division number 1 in Money Appeal number 141/2020, whereby the suit filed by the present appellant was dismissed. Issue notice to the dismiss. Stop. This appeal is admitted. Let the records of money suit number 141/2020 be called for from the trial court. The registry to take steps for requisitioning the trial court records. Issue notice to the respondents. You are appearing for?
For recommend number 1, yeah.
What is your name?
Burua on behalf of C. Burua.
Issue notice to respondent. Since respondent number 1 is represented by Mr. R. Boro, no formal notice need to be issued to the said respondent. You received the memo of appeal? Stop. As regards the other respondents. Other respondents,
So I have already charged Lordship Government, Commissioner and Secretary Government of Assam and Deputy Commissioner. And 4th is additional Deputy Commissioner. I have already started, Lordship.
to the engaged government count.
Yes, Lordship. I may be served extra copy, Lordship.
This is item number
11, Lordship.
11. Why their names is not indicate? Not in, if you have some, Mr. Burua, you are appearing for central government.
Yes, my lord, that is for, yes, number 1.
Okay.
That's for number 1.
Registry may be directed, Lordship, to name the reflect the name of the
Where is the notice?
last part, Lordship.
Is no, it is only served on the central government council, not on this.
Then Lordship, I may.
You take steps.
Yes, Lordship.
The appellant shall take steps for issuing the notice to the government council representing respondent number 2, 3, and 4. No, line to continue. The appellant shall take steps for issuance of notice upon respondent number 2, 3, and 4. The learned counsel for the appellant is allowed to serve the said notice on the government advocate for the state of Assam within a period of 7 days from the date of this order. Let the records call hoigul. Let this matter be listed after 4 weeks, 2nd of April.
Item 49 from supplementary.
Your Lordship, Mr. D. Senabati is on legs, Your Lordship. My Lord, may kindly take it up at 2 if possible, Your Lordship.
When?
At 2, Your Lordship, if possible, Your Lordship.
If not possible, okay.
He's on legs, Your
Okay,
Lordship.
we will take after something. In the second half, in the second. Okay.
Much obliged, Your Lordship.
Orders, item 12.
Lordship, here we pray for a short accommodation, Lordship. We have filed our additional affidavit only yesterday of paper publication upon response number 2. So it is most probably not on record. So 1 week time may be granted, Lordship.
Heard Mr. S.P. Sharma, learned counsel for the appellant, who submits that they have filed their affidavit in compliance regarding issuance of notice upon respondent through paper publication. However, the said affidavit is not on record, and therefore prays for calling the said affidavit on record. Registry is directed to list the matter, place the affidavit filed by the appellant in the record on the next date fixed.
6th of March.
Let this matter be listed on 6th of March.
Item 13.
Lordship, as the LCR is received, the matter may be fixed for hearing, Lordship.
The notice,
We served upon them, Lordship, and their name has been also shown, Lordship. Extra copy was also served, Lordship.
who is the respondent?
B Deka, Lordship.
Names are shown in the heard miss. What is your name?
SP Das, Lordship.
SP?
Das.
SP Das, learned counsel for appellant. None has appeared for the respondent, though name of engaged counsel is shown in the cause list. Since this matter is ready for hearing, list this matter for hearing on 21st of April. Or it is served.
Yes, Lordship.
You serve the extra copies. 11, item number 11 on taking fresh steps on government advocate, it to continue.
Their name will be reflected, Lordship.
Dean, it appears that notices are also served on the government council representing respondent number
2 and 3, Lordship.
2 and 3. The registry is directed to reflect the names of Government Advocate Assam in the cause list as engaged counsel for respondent number 2, 3, and 4. 4 also. Okay, list accordingly.
Item 14.
My lord, in this case, my lord, respondent counsel received the copy from by hand, my lord, they have received. My lord, on 24/2/2025. Although notice has not been served, my lord. And I have informed in the morning also, my lord.
What is this?
My lord,
What is this? This I is for
I have a stay of operation of my lord, order, my lord. Or
what order?
my lord, judgment and order dated 8/6/2022 by past railway claim tribunals, my lord.
What order was passed?
My lord,
You are claimant or railways?
I am for the railway, my lord, appellant.
Let the other side appear.
My lord, I have already informed and they have received the copy.
Who is the counsel?
My lord, original counsel Maheshwari KP Maheshwari, but one Manasi Kolita junior to her, him, my lord, received copy from 24/2/2025, my lord. By hand.
Item number?
14, my lord.
Their names are not shown in the
Not
cause.
shown, my lord.
What is your name?
My lord, Manasi Kolita.
What is your name?
My name PS
P-
Bhattacharya,
Third Mr. P.S. Bhattacharya,
CGP, my lord.
Learned Central Government Council, who submits that he has served a copy of this interlocutory application along with memo of appeal to the counsel for the respondents. And where is that notice? You filed that notice.
My lord. There are the steps taken but unserved notice, my lord. But later on they, by hand they received, my lord.
He prays for. You have submitted that notice where they have put their signatures.
No, my lord, they put their signature on the MFA, my lord. Directly copy received from me.
You file an affidavit that you have served.
My lord, my lord.
Learned counsel for the appellant/applicant seeks time to file an additional affidavit to bring on record the fact of service of notice on the engaged counsel for respondents. The prayer is allowed. Let this matter be listed on 13th of March.
Obliged, my lord.
Item 15.
My pleasure also. Lordship, in this case, we have served a notice to Dusty Lordship. And in that regard, I have called the Dusty affidavit also, Lordship. It was duly served upon recipient number 1 and 2. This is a claimant's Lordship.
How many respondents are there?
3 respondents.
Who is the third?
1 and 2 are the claimant, and third one is the owner of the vehicle.
And as regards the owner?
Owner received writing, Lordship, but not appeared. And there is a delay in this case.
This I is for?
Delay condemnation, Lordship.
Heard Mr. P.J. Burman, learned counsel for the applicant in IA. Learned counsel for the applicant. As regards number 3, what? You have taken steps.
Lordship, I think this receipt, I couldn't go through the record, Lordship, because that's not have it, right? I think he's received. And regarding 1 and 2, there was a direction to serve notice through Dusty because it was written answered. So accordingly, we served Dusty, Lordship.
No, 3 affidavit has not arrived.
I have to check the office record.
3 has not. Against respondent number 3, notice has not yet been served. Not served. You have to take steps.
In that case, also, Lordship, we can, if Lordship permits.
Dusty.
Dusty, Lordship. Otherwise, it's a settleable case, Lordship. In last local Adalat proceeding also, Lordship, we tried to contact to settle the matter, Lordship.
No, you say, serve the notice first.
Yes, Lordship.
Learned counsel for the applicant has submitted that as regards respondent number 1 and 2, the notice were served on them by Dusty mode, and in that respect, an affidavit of compliance has been filed. I have gone through the affidavit filed by the applicant, which is along with which the copy of notice on which the signatures of 1 and 2 are appended are there. Considering the averment made in the affidavit filed by the applicant, as well as on going through the copy of notice annexed therewith, the notice issued to respondent number 1 and 2 are held to be duly served. However, as regards respondent number 3, no service report has been received. Hence, the applicant is directed to take fresh steps by way of speed post to the respondent number 3 within 7 days from the date of this order, returnable on 30th of March.
Dusty maybe also
The
permitted.
applicant is also allowed to take additional steps for issuance of notice by way of Dusty stop. In the event the notice are served by Dusty mode, the applicant shall file an affidavit in compliance thereto on the next date fixed. Let this matter be listed on 30th of March.
Obliged.
Item 16.
May I please, Your Lordship, the engaged counsel B. Nath had requested me that he will withdraw the wakalat order. He had contacted the client, but some instruction had to come back.
Otherwise, this matter become infructuous. What happened, they challenged an ad interim expertise order in 2023 and the extension order of that injunction order. Thereafter, this appellant has filed written statement and written objection.
There.
There.
Okay.
Thereafter. And the matter has been fixed on now 18/3. No, 18/3. On 18/3 for hearing. So otherwise this matter and the hearing could not take place.
Now they are saying that they are withdrawing the wakalat. How to deal with this issue? Somebody has to represent them. Is there no stay is there?
No stay.
So let them say.
The difficulty is, my lord, during the pendency of this appeal, also keep the trial court one of the put in question to dispose of the matter. That's the difficulty. The pendency.
We'll make clarify.
Yes.
Heard, Mr. What is your name?
Sharma.
P. Sharma.
We have a B. Nath.
Learned counsel appearing on behalf of B. Nath, who submits that the engaged counsel, Mr. B. Nath, is intending to withdraw the wakalatnama. The the counsel for the appellant may do so after informing the appellant by sending him a notice in that regard by way of registered post, by way of speed post, and the proof of sending that such notice may be produced before this court on the next date fixed. On the other hand, learned senior counsel Mr. B. Datta, assisted by Mr. S. Deka, has submitted that this matter has become infructuous inasmuch as inasmuch as this appeal has been filed by the appellant impugning an order of interim injunction was granted.
On 4/11/2023.
Order of interim injunction dated 4/11/2023. However, the present appellant has appeared before the trial court and also filed objection
On 8/2/2024, my lord.
on 8/2/2024 before the trial court. Stop. Learned senior counsel submits that though no stay has been granted in this appeal, however, due to pendency of this appeal may impact the disposal of the
Miscase number 283.
disposal of the miscase number
283
283 of 23 by the trial court.
which is fixed on 18/3/2026, my lord.
He also submits that next date of the said miscase is fixed on 18/3/2026. Stop.
If I am appearing for exponent number 4, so I am endorsing the submission of.
Mr. M. Dotto appears for respondent number 4. He adopts the submission of learned senior counsel for the respondent number
1, 2,
1, 2, and 3. Stop. Considering the facts and circumstances of this case, where the engaged counsel of the appellant is intending to withdraw his wakalatnama, this appeal cannot be disposed of at this stage. However, it is hereby made clear that pendency of this appeal shall not be a bar for the trial court to proceed with the Ms. J case number
123.
283.
283.
283 of
23.
2023. The trial court shall make all endeavors to dispose of the said Ms. case as expeditiously as possible. List this matter 23rd of March.
Obliged. Item 17.
Actually, in this matter also, we pray for a short accommodation because we have filed our affidavit yesterday, newspaper publication.
Newspaper
I am appearing for respondent number 1.
For 2, we are taking the paper publication. 1 week time maybe.
Heard Mr. S.P. Sharma, learned counsel for the applicant / appellant. Also heard Mr. K.R. Padgiri, appearing for respondent number 1. Learned counsel for the applicant submits that the applicant has filed his affidavit in compliance regarding issuance of notice upon respondent number 2 by way of paper publication today only. Yesterday only, and the said affidavit is not on record. He therefore prays for directing the registry to place the said affidavit on record. Registry to do the needful accordingly. List this matter
11th of March.
on 11th of March.
Item 19.
In this case, respondent number one has appeared. Regarding service of respondent number two, AD card has not yet returned, let's say.
In respect of,
Respondent number two. Papers taken by registered post also.
the trial court registered post when?
In the month of February 2025.
February?
February 2025.
But you were directed to take fresh steps on 12/2/2025. You have not taken any fresh steps.
The step was taken by registered post, not by usual manner.
Okay, okay.
Now I shall take step by as usual manner. That's
As well as by speed post.
speed post regarding speed post, it does not return till now.
No, now we cannot. You have taken steps when?
24/2/2024.
Which date you have taken steps?
As per my record of 24/2/2025.
Two, so we cannot even call for postal track consignment report. You take fresh steps. Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Ms. P. Burwa, learned counsel appearing for respondent number one. On a perusal of the office note, it appears that the notice issued to respondent number two has not returned. So the appellant is directed to take fresh steps for issuance of notice upon respondent number two by way of by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 March. List accordingly. Also issue reminder for the trial court records.
Item 21.
Your Lordship, this is a delay condemnation petition, and we were directed to take steps of paper publication on respondent number one. Accordingly, we have taken steps and the affidavit is on record, Your Lordship.
How many respondents are there?
Two. One was already served. Two was already served earlier, Your Lordship, respondent number two. And with respect to respondent number one, since the steps could not be taken, we were directed to take steps of paper publications.
Heard Ms. A. Biani, learned counsel for the applicant, who submits that in pursuant to the directions of this court, the applicant has taken steps for issuance of notice on respondent number one by substituted mode of paper publication. And in that regard, an affidavit in compliance has also been filed by the applicant. The newspaper in which notice has been published has also been annexed along with the affidavit. After going through the notice as well as what was the date of appearance in the notice? Going through the notice as well as the annexed news as well as the averment made in the affidavit, it is hereby held that the notice issued to respondent number one is duly served. It appears that in respect of respondent number two, the service of notice is complete and an order to that effect has been passed by this court earlier on 24/7/2024. What is the date?
Lordship, 28/5/2025. It has already gone.
28/5.
Yes, your lordship, 2025.
Then why are you filing affidavit after so long?
Should we file it earlier? We filed it on 5/6/2025.
So this matter was not listed.
It was not listed for a long time. Your lordship.
Okay. Stop. How much delay is there?
224 days.
What is the reason?
Your lordship, procedural delays, seeking legal opinion, routing of the files.
What is section 33 of the Employees Compensation Act? This application under section 30 within bracket 3 of the Employees Compensation Act 2023 read with section 5 of the Limitation Act has been filed by the applicant National Insurance Company Limited, praying for condonation of delay of 223 days
24.
in filing the, what is there?
Your lordship, section 30 subsection 3 specifies that the provisions of limitation act shall be applicable to the.
Read it.
The provisions of section 5 of the Limitation Act 1963 shall be applicable to appeals under this section.
224 days.
Yes, your lordship.
224 days in filing of the appeal, connected appeal, whereby the judgment dated 6/3/2023 passed by the Commissioner, Employees Compensation Nagaon in NEC within bracket WC case number 238 of 2003 has been impugned. The learned counsel for the applicant has submitted that the delay in preferring the connected appeal within the prescribed period of limitation has been caused due to the procedural delay, which has been explained by the applicant in paragraph numbers
4 to 7.
4 to 7 of the instant application, instant interlocutory application. Stop. After considering the submissions made by learned counsel for the applicant, as well as after going through the averments made in paragraph number 4 to 7 of the instant interlocutory application, this court is of considered opinion that the cause shown for delay in approaching this court belatedly has been properly explained by the applicant, and same may be regarded as sufficient cause which prevented the applicant in approaching the court in filing the connected appeal within the prescribed period of limitation. Stop. Accordingly, the delay of 204 days in filing the connected appeal is hereby condoned. Stop. The registry is directed to register the connected miscellaneous first appeal and list the same for admission after a week. This interlocutory application is accordingly disposed of.
Much of it.
Item 23.
Yes.
So this is an IA for condemnation of delay in filing substitution of legal error. But as per office note dated 23/6/2025, the notice upon the legal error of respondent number 2 came unserved and came unserved. The notice was issued on 21/1/2025.
As per office note dated,
23/6/2025. When notice upon the legal heir of the respondent number 2 came unserved.
not it. It says that neither the unserved notice nor AD card.
Yes, Your Lordship. Neither unserved notice nor AD card.
Though word unserved is there, it does not mean that it has.
Yes, Your Lordship.
It says that
Neither
no notice has come
back. Yes.
back.
Yes, Your Lordship.
So what is to be done?
It's been 1 year, Your Lordship.
You take fresh steps.
By usual process, Your Lordship.
Heard Mr. S. Sharma, learned counsel for the applicant. On perusal of the office note dated 23/6/2025, it appears that the notice issued to respondent number 3 and respondent number 2 within bracket A has not yet been returned. The applicant is therefore directed to take fresh steps for issuance of notice on the respondent number 2A by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of.
Lordship, there was another IA which was filed, which is not on record, Lordship. It was the IA for substituting the name of the legal heir or respondent number 2. The filing number is.
What is the number?
The filing number is 5244. It was filed on 8/5/2024.
Yes.
It is not on record. Only 2 IA which has been filed after that have come into record. 1738 and 1739. There was another IA which was filed.
Where is the filing? What is the filing number?
Filing number is 5244 of 2024.
Learned counsel for the applicant has submitted that the applicant has filed another interlocutory application. The filing number interlocutory application in connection with MFA number 67/2021.
No,
2022. The filing number of the said interlocutory application is
5244
5244
of 2024.
of 2024. Registry is directed to place the said interlocutory application along with the records of this case on the next date fixed.
Item 24.
May I please? The Sultan may actually come for admission. This is a regular first appeal, my lord. This case is IA is for stay of the impugned order, my lord.
Main appeal.
Delay already condemned.
It was already admitted.
Was admitted.
Lordship. By order dated 6/11/24.
And
Whether records were called.
Lordship.
And for the admission, my lord, this is for stay, they took time for filing objection, my lord.
Heard Mr. M. S. Soikia.
My lord.
S. Soikia, learned counsel for the appellant in main appeal. Appealot likhibo. Also heard Mr. B. J. Mukherjee appearing for how many respondents are there?
Number 1.
Appearing for this.
There are totally 3 respondents.
Respondent number 1. You have to take steps with regard to other respondents. The appellant shall take steps for issuance of notice upon the remaining respondents, that is respondent number 2 and 3, by speed post as well as by usual mode within 7 days from the date of this order, returnable on 13th of March, 30 March. It also appears that the records of the trial court have not been received. the registry to issue reminder whether trial court records are necessary.
That may be called.
Issue reminder for the trial court's record. List accordingly on 30 March. In stay application,
The application, Lordship, let the notice be served on the other two respondents as well.
stay application, same. Mr. S. Sakia and B.J. Mukherjee for applicant and respondent. It appears that notice to remaining respondent have not yet been served. The applicant is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days of the date of this order, returnable on 30 March, released accordingly.
Item 25.
Also, in this case, the R2 could not be found. It can be struck off, Lordship. This is an appeal on quantum. I am challenging the percentage of disability.
Who is R2?
R2 is the owner of the bill. It's a MFA.
Otherwise, you are not disowning the liability.
Not dishonoring. I'm just
Yeah.
telling the quantum of
Quantum. Okay,
Your
we,
Lordship, I am for respondent one. Your Lordship, I have a prayer for withdrawal of the deposited amount, which has been deposited before the registry.
you have filed any interlocutory
No,
application
Your Lordship.
where I will pass that order.
Okay, Your Lordship, we'll file an act.
You file an interlocutory application.
In the meantime, Lordship, LCA has been received.
Okay, heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. S.
That's for respondent.
S. Dutta, appearing for respondent number 1. It appears that notice to respondent number 2 has returned with an endorsement that it could not be served as no such person was found in the given address. Stop. Moreover, the local people of the area also declared that no such person is known to them. Stop. Learned counsel for the appellant has submitted that the appellant has preferred this appeal mainly on the question of quantum of the compensation awarded to the claimant, and they are not disowning their liability. Hence, he submits that the name of respondent number 2, who is the owner of the offending vehicle, may be struck off. The counsel for respondent number 1 does not raise any objection to the said prayer. Hence, the prayer is allowed. The name of respondent number 2 may be strike out from the memo of appeal. The registry to do so. Stop. Records of the trial court have been received.
Yes, Lordship. It says LCA received.
The records of the trial court have already been received. Hence, this matter appears to be ready for hearing. List this matter for hearing after 4 weeks on a date to be fixed by registry.
Item 26.
May I please, Your Lordship. I prayed for my lord to withdraw only 5 lakhs amount of awarded total amount 7 lakhs, my lord. On condition of serious illness, already submitted additional affidavit, my lord, in this case, of the mother of the deceased. I appellant number 2, my lord.
Who is for the other side?
My lord, other side, last also I was called her. But at 2 p.m. my lord, I will communicate with him.
Okay.
Item 27.
My lord, we may be allowed to take dusty service.
Your husband or wife?
On the last occasion, notices were issued, and pursuant to the last order, we had taken steps upon the respondent.
How many respondents are there?
2 respondents, 5 and 6.
Heard, miss, what is your name?
P. Devi, my lord, on behalf of Mr. P.R. Sharma.
Heard, Miss P. Devi, appearing on behalf of Mr.
P.R. Sharma.
P.R. Sharma, learned counsel for the appellant. Also heard Mr. K.K.
I
Bhattacharya,
am appearing for respondents 2, 3 and 4.
appearing, learned government advocate, appearing for respondent number 2, 3, and 4. On perusal of the office note, it appears that the notice issued to respondent number 5 and 6 have not yet returned. Stop. The registry is directed to place the postal track consignment report in respect of the notices issued to respondent number 5 and 6 by speed post, on the next date fixed. Stop. It also appears that the trial court records have been received. Short date. Let this matter be listed on 13th of March.
Item 29. Item 31.
Your Lordship, I beg to appear with your Lordship's leave to file wakalat. We have not been served in this matter. Through the market rumors, we have come to know a certain appeal has been filed by the appellant company. There was a direction, we have seen the records.
For whom you will be
A
appealing?
respondent company. The
How
sole
many?
respondent.
How many?
The sole respondent.
Sold. Let them appear.
Lordship, we will file the copy, Lordship.
We have not been served. There was direction upon them on 15th of December. There has been
Notice
no
of
service.
No,
Lordship.
they have
Track as
taken,
usual process, Lordship.
they have taken steps. However, it has not been served. They will furnish you copy
Copies.
now.
They were aware of this matter since inception. We are in this matter. There was an ex-party order. The appeal was
Okay,
proposed.
let them file now.
I will
Heard
keep it
Mr.
there,
S.K. Poddar, learned counsel for the appellant. Also heard Mr. What is your name?
K. Kashyap.
K. Kashyap, who submits that
Number.
he has been instructed by the respondent to appear in this case and seeks some time to file his wakalatnama in this case. The prayer is allowed. The appellant is directed to furnish a copy of memo of appeal will annexures along with the copy of interlocutory application to Mr. Kashyap within 2 days from the date of this order. List this matter again on 20 March.
Obliged, Lordship.
20.
Can it be before that?
18th March.
Actually, one additional submission which we request the other side to not to recommend their client or advise their client to not make any adversive comment in the market. These are fast moving.
Adversarial comments, Lordship. Conjunction is in their favor.
We have
Our
obtained,
business has been stopped.
there is no business. This was with respect to a trade dress.
Where
And
is the
our
mention of
order was
adversarial comments? It is
confirmed.
not a case of.
No, you first file wakalatnama.
Yes, we'll file.
Thereafter, I'll
Much of it. Before that, if you need it.
18th.
Much of it.
18.
Item 33.
Yes.
Who is for the appellant? None has appeared. None has appeared. What is your name? Oh, you have not taken steps.
Taken step, my lord, on 17/2/2026. On respondent number 2, my lord.
Today,
No, my lord,
yesterday,
17/2.
17/2.
Yes,
Today is
18 months.
18. Date change kone kone. Third, Mr. What is your name?
AK Das, my lord.
A.K. Das, learned counsel for the appellant. Also, Mr. S.P. Sharma, learned counsel for respondent number 1. Though the office notes shows office note dated 16/2/2026 shows that no steps was taken by the appellant for issuance of notice to respondent number 2. However, learned counsel for the appellant submits that he has taken steps yesterday only. He has taken such steps yesterday only. Stop. In view of above, let this matter be listed on 20 March, awaiting the service report of notice issued to respondent number 2.
Item 34.
May it please your lordship. Lordship, as per office note dated 16/2/26, postal tracking for 1, he is appearing. For 2 and 3, lordship, postal tracking report of 2 and 3 show item delivered on demand and flag A is the. Lordship, this is ready for hearing, any date, lordship, in March.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr.
AB there, my lord.
A.B. Day.
My lord,
Appearing
for a moment, I'm so sorry, my lord, to interrupt. My lord, for a moment, we'll peruse the order dated 10/12/2025 for a moment, my lord. And thereafter, my lord, because this is a case of pay and recovery, my lord, otherwise.
So that's what I'm submitting, lordship. It can
If-
be heard finally any date. Only not in February, I'll be out of station, lordship, March.
If my lord thinks that, I'm just suggesting as an officer of the court, my lord, because this is a case of pay and recovery. And as per the office note dated, my lord, this delivery was done on 12/1/2026. The package to the respondent number 2 and 3, I think respondent number 2, the owner,
2 and 3 both.
were done on 12/1/2026, my lord. So what I am suggesting, my lord, is that can it be on 7th of April otherwise? Because then they might also have some amount of time.
Okay.
Just that to be fair to the
I was
fair.
suggesting March.
No, that is okay, but just that I have pointed out to the court.
On perusal of the office note dated 16/2/2026, it appears that the postal track consignment reports of notices issued to respondent number 2 and 3 shows that the notices were delivered to them on 12/1/2026. I have perused the said postal track consignment report. In view of above, the notices issued to respondent number 2 and 3 are held to be duly served. Stop. Since the record will not be necessary.
It has come.
It is already come. It will be next.
Already.
Record of the
LCR is already here, my lord.
concerned motor accident claims tribunal has been received. This matter is ready for hearing. Stop. Accordingly, list this matter
7th of April,
on 7th of April for hearing.
Deeply obliged, my lord.
Item 45.
Item number 35 and 36, my lord, the appeal is barred by limitation. Well, that limitation is 2 years, 1 day.
You are the appellant.
Yes, my lord.
So
Service to railways will have to be served, my lord.
They have not appeared.
This is delay condonation application.
Yes, my lord. Delay condemnation application, my lord. We have copy now.
On railways also.
Copy, they appeared.
Who is appearing for railways?
Only file objection, not I'm appearing on behalf of R Devi. She is in the matter.
You'll file objection.
File objection.
My lord, your lordship would be pleased to consider that first order was passed in this case on 10/3/2025, my lord. About 1 year, my lord. This limitation is pending. They are not filing objection.
No, my lord,
Times are
these
taken.
the railways were served later after that date.
Okay, let them file objection. We'll give short date.
Because it's a long condonation delay, my lord.
Yes.
That's all right, my lord, but further time should not be granted. Either it will be allowed or it will be rejected. Otherwise, it will be.
Now what should I do?
My lord, no, my lord, thing is this, my lord, it should not be pondered more. Mass delay should not be.
I'll ensure, my lord.
For condonation of delay, my lord, 1 year, that's not. Seems to be
Heard
right. my
Mr.
lord.
M.A. Sheikh, learned counsel for the applicant. Also heard Mr. K.K. Bhattacharya,
And for respondent one, my lord.
appearing for respondent number 1, as well as Mr. H. Gupta, appearing for Miss M. Devi,
Devi, my lord.
Miss R. Devi, learned counsel for the railways, respondent number 2, who submits that some time may be granted to file written objection against the condonation of delay application filed by the applicant. The prayer is allowed. Let this matter, when
My lord. Outerly 2 weeks after, 10 days, my lord. 16th of March.
16th of March,
But
let this matter be.
there should be some indication that it is already delayed. My lord, much time has gone. That was
No,
my submission, my lord. Otherwise, same thing will happen. Same thing will happen, again time will be taken.
on that day,
From my experience, I am telling, my lord. They are taking time. Because there are panel advocates, they are not interested to
He's
fight.
having some medical problems also.
So indication may be there, my lord. Just one word will do.
before the prayer is allowed, Jitu likhilo. Tat likhibo. Learned counsel for the applicant submits that this interlocutory application is pending for more than 1 year, and therefore she opposes the grant of
Not more than 1 year, about 1 year, my lord.
for about 1 year. Therefore, he opposes the grant of any further time to the respondent number 2 for filing written objection. Stop. However, I have considered the submissions made by learned counsel for the applicant. Since the delay involved in this case is also a huge delay of more than 2 years, the prayer for filing written objection is allowed. Let this matter be listed on 16th of March. 36, same order.
Same order, my lord.
Same order.
Same order. Obligation.
1047. Item 30.
None appeared for the applicant on call. List this matter next week at the date. On 26th of February.
Item 38.
As per office note dated 12/2, the notice of the respondent number 1A has been received by respondent number 2. And regarding 3 and 4, there is service is awaited. So we'll take fresh steps because earlier we have taken a step in the year 2005, April 2025.
Heard Mr. S. Deka, learned counsel for the applicant. This is delay condonation.
Yes,
Lordship, I am for the 1A.
please appear for 1A.
Also, Heard Mr. What is your name?
R.K. Mohanto on behalf of
R.K.
A.K. Gupta.
Mahanto, appearing for respondent number 1 on perusal of the office note dated 12/2/2026, it appears that the notice to other respondent have not yet been received. 2 and 3,
Two has received the notice for 1A. Regarding 2, there is no any remarks. But 3 and 4 stated that they awaited.
1 and 1A are different person.
No, 1A is the legal heir.
And
Because in between, he has died.
whom you are appearing?
1A.
For? 1A. 1A लिखो. It appears from the office note that
Okay, we will file objection in this regard.
no, where is that endorsement that 2 has received for 1?
12th. Office note 12th.
12-2.
Who is Rajiv Kumar Shukla?
Rajiv Kumar Shukla is the respondent number 2.
Okay. On perusal of notice, office notice, it also appears that respondent number 2 has also received the notice. However, the notice service report in respect of respondent number 3 and 4 are awaited. The applicant is directed to take fresh steps for issuance of notice on respondent number 3 and 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30 March.
They want to file.
We will file
in the meeting.
In the meanwhile, the respondent number 1A may file a written objection against the prayer for condonation made by the applicant.
Obliged.
39.
To the lordship, the service is complete. R1, R4 and R5 has notices have been delivered and R2 and 3 are minors.
Lordship, I am appearing for respondent number 1, 2 and 3. Lordship, I have received the copies of the IA today morning. Lordship, I need some 3 weeks time.
For filing objection.
Okay. If required, madam.
Heard Mr. R. Goswami, learned counsel for the applicant. This is condonation.
Yes.
Applicant. Also heard Mr. M. Dutta, who appears for respondent number 1 to 3 and who has prayed for some time to file written objection against the prayer for condonation of the delay made by the applicant. In respect of 4 and 5?
4 and 5 is delivered on the next day, maybe they might appear.
It appears
They are necessary.
from office note dated. It appears from the order dated 18/11/2025 passed by the Lawazima Court that the notice sent to respondent number 4 and 5 have been duly served. Stop. List this matter again after 23rd March.
Item 20.
Yes.
Lordship, we have filed an IA 3727 under Order 6, Rule 17, read with Section 151 of CPC for amendment of a typographical error.
In the memo of appeal,
Your Honor,
where,
Lordship,
where typography?
in the synopsis and cost title, Your Honor, page 4.
Of the your testamentary appeal, testamentary case.
The section was mentioned as Section 299 instead of Section 384 of Indian Succession Act.
Heard Miss, what is your name?
M. Padgiri.
Heard Miss M. Padgiri, learned counsel for the whether the respondents have appeared.
Yes, Lordship.
They have appeared
Yes, Lordship.
in this case,
No, in the main case.
in the main
In
case.
case, in the interest appeal, Your Honor.
Who is appearing?
Miss Lonnie Das, L. Das.
Heard Miss M. Padgiri, learned counsel for the applicant. Stop. None has appeared for the respondent, though the name of Miss L. Das has been reflected in the cause list. This application under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure, has been filed by the applicant praying for amendment, praying for rectification of some typographical mistake which has crept in the in the memo of appeal filed in the connected intestate case number 2/2025. The appellant has sought, learned counsel for the applicant has stated that the relevant provision of law quoted in the memo of appeal has been wrongly mentioned due to typographical mistake, and same is required to be corrected. Stop. Considering the fact that the amendment sought is only in respect of the mentioning of correct provision of law in under which the appeal has been filed, this interlocutory application is allowed. The applicant is directed to submit the rectified cause title in the connected cause title in the memo of appeal of the connected testamentary case within a week from the date of this order. This date of this order stop. After submission of after submission of the rectified memo of appeal, a copy thereof shall also be furnished to the learned counsel for the respondent on the next date. Let this matter be listed again on Patul date at the 20th of March, 20 March. This interlocutory application is accordingly disposed of.
Item 41.
May I please the question? My lord, this IA is for releasing 50% amount. That amount has already been deposited, Lordship.
Any objection?
Your Lordship, our objection is on record.
What objection?
Your Lordship, the ground of appeal is misrepresentation of facts. So, and the amount deposited, which is 50% of the entire amount, amounts to around 30 lakhs. So it is a big amount, Your Lordship. If it is allowed to be withdrawn at this stage, then recovering it back from the claimant will be a big task.
What is the stage of appeal?
Your Lordship, appeal has been admitted.
Just admitted on Lordship, admitted on
October
29/10/25.
October 2025.
What is the status?
The lower court record, the trial court records have not been received yet, Your Lordship.
Not,
If the trial court records can be called for a short.
What misrepresentation of facts?
Your Lordship, in the claim petition, the claimant stated that his deceased wife was a pedestrian and was going to work. However, in the cross-examination, he has admitted that she was given lift by an unknown vehicle. And he has also admitted that he has not made the owner, driver, and insurer of that unknown vehicle a party in the case.
My lord, the stand taken in the appeal, Lordship, has not been proved. Only on the basis of the Lordship statement recorded by the by an officer of the insurance company of the Lordship, the owner of the vehicle. He told that while the offending vehicle was driven by his brother, and when he was proceeded, another scooty, Lordship, where the pillion rider was the deceased. That was, Lordship, extremely on the side of the road, and the offending vehicle, Lordship, slightly touched that scooty, and pillion rider fall down. That is the statement of the owner of the vehicle. But owner of the vehicle.
Who are the claimants?
Claimants, Lordship, husband and Lordship, children of the deceased. But husband, Lordship, claimant number 1 has already expired on 19/1/2026, Lordship. And now, Lordship, only the children, daughter. My lord, there is no evidence to that effect. Even the owner of the vehicle was not, Lordship, put before the court for evidence. Unnecessary, Lordship, they are only because.
No, suppose appeal fails, appeal is allowed. Will you be in a position to refund?
Lordship, that condition may be impossible.
No,
Because
imposing condition is not important. What is your, will you be in a position to refund back that is important.
Lordship, I will submit the bond to that effect. Because this is a clear case, Lordship, my submission would be that it is a clear case that they will lose the Lordship appeal. Because that should be, appeal should be decided on the basis of the record, evidence, but nothing is on that. Your Lordship may pass an order to the effect that the claimant will submit the bond, and in the event failure, Lordship, appeal is allowed, we will refund that amount. No problem on that.
Your Lordship, on the other hand, the trial court records can be called for and a short date of hearing can be given. The matter can be decided at once. And if
2025 matter, your Lordship is ever, it will take time, Lordship. Now, Lordship, only this children, Lordship, they are minor, they were minor at the time of incident. Now they become major.
Will make appeal though.
If your Lordship kindly come to one paragraph of the judgment in the appeal, your Lordship will clear on that. Page 31 in the appeal. This is the basis of their appeal.
Page 31 of the
Of the appeal, Lordship. second paragraph. DW1. Based on this statement, lordship, they prefer this. In the event their extent is lordship consider, in that event also lordship, that vehicle was the offending vehicle. DW1.
Who is this opposite party number 2?
The owner of the offending vehicle.
Whether he has reduced his
No.
evidence.
That is the case, lordship. Neither he nor his brother who was driving the vehicle.
You furnish indemnity bond. Third, Mr. M. Khan, learned counsel for the appellant, learned counsel for the applicant. Also, Miss A. Biani, learned counsel for the M. Khan for applicants, plural. Miss A. Biani appearing for respondent number 1. Who is appearing for other? No, in the interlocutory application. Oh. What is your name? Miss G. Devi appearing for the owner and driver. This interlocutory application has been filed under section 151 of the Code of Civil Procedure by the applicants / claimants praying for a direction for disbursement of 50% of the awarded amount, which was deposited by the respondent, by the insurance company in the connected appeal as a condition for grant of stay of execution of the impugned judgment and award. So this court, by order dated 29/10/2025, passed in IS Civil number 3295/2025, directed the insurance company to deposit 50% of the awarded amount before the registry of this court as a condition for stay of any execution of the awarded judgment and award. Stay of any execution of the judgment and award. So, accordingly, the insurance company, had on 21/11/2025 deposited the 50% of the awarded amount, that is rupees 30,99,720. Learned counsel for the applicant has submitted that the applicant who were the claimants and who have been and in whose favor the impugned order was passed are economically poor and needy persons, and the connected appeal being an appeal of the year 2025 may take much time for disposal, considering the pendency of MAC appeal in this court. Hence, he has prayed for allowing the applicants to withdraw the deposited 50% of the awarded amount. Stop. Learned counsel for the applicant has further submits that the appeal preferred by the insurance company is devoid of any merit, and it is likely to be, and ultimately it is likely to be dismissed, and therefore depriving the claimants / applicants from the fruit of their litigation may not be just. On the other hand, Ms. A. Biani, learned counsel for the insurance company, has objected to disbursement of the amount deposited by the insurance company before this court in pursuant to the directions of this court. She submits that there is every possibility of the appeal being allowed ultimately, and in such a case, if the amount, 50% amount which has been deposited by the insurance company, which is a substantial amount of, which is a huge amount of more than rupees 30 lakhs, it may be difficult on the part of the claimant to refund it back, even if they are directed to do so. Hence, she submits that instead of disbursing the deposited amount, the connected appeal may be taken up for expeditious hearing. I have considered the submissions made by learned counsel for both sides. Without going into the records of the connected appeal in depth, it may not be possible at this stage to state as to in whose favor the appeal would be ultimately be decided. Stop. However, it appears that the present claimants were the beneficiary of the impugned judgment and award, and the connected appeal being an appeal of the year 2025. In normal course, it may not be taken up for hearing at the earliest due to pendency of huge number of MAC appeal before this court. And under such circumstances, it may not be appropriate to deprive the beneficiary of an judgment and award from getting at least 50% of the awarded amount during the pendency of the connected appeal. Hence, this stop for the discussions made and reasons stated in the foregoing paragraphs, this interlocutory application is allowed. The registry is directed to disburse the amount of rupees 30 lakhs 99,720, which was deposited by the insurance company in pursuant to the directions passed by this court on 29/10/2025 in IA Civil number 3295/2025. Stop. Before disbursing the amount, the registry shall properly verify the identity of the claimants. The claimants shall also furnish an indemnity bond undertaking therein that in event of the allowing of the connected appeal, they shall refund back the amount which will be disbursed to them in pursuant to this order, as and when directed to do so. Stop. In view with above observations, this interlocutory application is disposed of.
One thing may be recorded also. Applicant number 1 has already expired. And amount may be released in favor of the remaining applicant number 2 to 4.
Stop. The 8 line before the 2-3 lines before. Learned counsel for the applicant has also submitted that during the pendency of the appeal.
Yes, no, it is just lost 19/1/2026 after filing this IA.
Okay. That during the pendency of this interlocutory application, the claimant number 1 has expired, and therefore the amount of 50% may be disbursed to the remaining claimants. The prayer is allowed. The registry shall do so in terms of the directions given herein below. What will happen in appeal?
The appeal also, his name may be lost in struck down.
No, why strike out?
Other already lost.
There's already there, so.
Children are already in the.
Let it remain.
Yes, Your Lordship, the legal is already arrayed as parties.
There is no. I have the.
Is it ready for hearing?
Not yet.
All have appeared. No, trial court record.
But the trial records have not appeared, the lower court records.
Heard Miss Abiani, learned counsel for the appellant. Also heard Mr. M. Khan, learned counsel for respondent number.
125 now, 225.
Learned counsel for respondent number 125, as well as Miss D. Devi, learned counsel for respondent number 6 and 7. Learned counsel for the appellant submits that during the pendency of this, learned counsel for the respondent number 1 to 5 submits that during the pendency of this appeal, respondent number 1 has expired. However, there may not be any necessity of substituting his legal heirs as they are already on record. Stop. It appears that the records of the Motor Accident Claims Tribunal, Motor Accident records of the MSC case number 188/2021 has not been received yet from the concerned tribunal. Issue reminder for the same. List this matter after 4 weeks after receipt of the records.
And then 42.
May please, Your Lordship, please, application of consideration of delay of 654 days, Your Lordship. In a similar matter, Your Lordship, you have passed an order. I am allowed to place the order, Your Lordship.
This is NJ matter. The NLU matter.
Yes, Your Lordship.
Yes, Mr. Bhattacharya.
I'm appearing for response 2 and 3, and there are other matters connected with this. So everything may appear in the cause list together. Then it will be convenient for the court, my lord.
Yes.
Because there are so many cases. So
And
they may be allowed to give a list of the cases. Then it may be
That would be convenient.
Yes, Your Lordship. And it will save the court's time. Present matter, you may be listed along with the order you have provided, Your Lordship.
Heard Mr. S. Das.
A Das, Your Lordship.
Sorry. A. Das, learned counsel for the applicant. Also heard Mr. K. Bhattacharya.
Why?
Yes, Bhattacharya, appearing for
2 and 3, Your Lordship.
state respondents. This application under proviso to section 74 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, read with section 5 of the Limitation Act, has been filed by the applicant, National Law University and Judicial Academy, Assam, praying for condonation of delay of 654 days in preferring the connected land acquisition appeal. Issue notice to the respondents. Since Mr. K. Bhattacharya has appeared for the state respondents, no formal notice need to be issued against the state respondent. However, as regards the respondent number 1, the applicant shall take steps for issuance of notice upon the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of March. Stop. Learned counsel. Execution case has been filed.
Yes, Your Lordship. Money execution case number 37 of 2025.
Learned counsel for the applicant has submitted that in the meanwhile, the decree holder, that is the respondent number 1, has already filed an execution case bearing execution case number 37/2025, which is pending before the court of learned.
Additional district judge.
Additional district judge Amingaon. Additional district judge Kamrup at Amingaon. He submits that unless the execution case is stayed, the applicant would be highly prejudiced, as there is a probability that in the execution proceeding, the accounts of the applicant, may be frozen, and the interest of students studying in the applicant university may be in jeopardy. Stop. I have considered the submissions made by learned counsel for both sides. Though the grant of a stay of execution in an application for condonation of delay in preferring the appeal is rare at the stage when delay is yet to be condoned, however, as the apprehension shown by the learned counsel for the petitioner indicates that the applicant, which is a law university where number of students pursue their academic career, may be jeopardized unless the stay is granted, this court is inclined to grant stay of execution in money execution case number 37/2025 till next date. List this matter along with list this appeal along with list this matter along with IA civil number 337/2025.
Much obliged.
List accordingly.
Item 43.
With your lordships, well, I for disbursement of releasing amount, my lord, rupees 11,71,000.
So I have to file an objection.
He'll file. Okay, let him file. This heard Mr. N. Barua, learned counsel for the applicant. Also heard Mr. R. Goswami, learned counsel for the insurance company. This application under section 151 of the Code of Civil Procedure has been filed by the applicant under section 173. 173, is there any provision for disbursement?
173, my lord. 173.
Once you deposit, if they make a prayer, it can be disbursed, but I want to file an objection on the grounds taken by.
No, क्या लिखा? This no, under section cut has been filed by the applicant claimants praying for allowing the applicants claimants to take the 50% of the awarded, 50% was deposited.
Yes, please. Yes, my lord.
50% of the awarded amount, which has been deposited by the insurance company before this registry,
14.
as a condition for stay of the execution of the impugned judgment and award. So, learned counsel for the insurance company prays that he may be allowed to file written objection against the prayer. The prayer is allowed.
In terms of LCR may be called for this.
Let this
Because
matter.
service is complete anyway.
Where is the main case?
Yes, ma'am.
Let this case be listed again on KTR.
Yes, it is received.
It's a receive already, my lord.
On 23rd of March, in main appeal, heard Mr. R. Goswami, learned counsel for the appellant, as well as Mr. N. Barua, learned counsel for the claimant's respondents. How many respondents are there?
5. No?
Who is appearing for driver and
No one is appearing.
No one appearing.
you have not taken steps?
I have taken steps. Steps taken.
2, 3 owner and driver. 4, 5, 6 son and daughters of the claimant, my lord.
The notice is issued to the remaining respondents have not been have not been received yet. Hence, the registry is directed to place the postal track consignment report of notices issued to other respondents within bracket except respondent number 1 before this court on the next date fixed. Let also the records of the MSC case number 12/2025 be called for from the concerned tribunal. The
Well, LCR
No,
already
these are
received, my lord.
already, isn't it?
Okay. এই line তো কাটো। The records of the MSc case number 12/2020 has already been received. List this matter again on 23rd of March.
Item 44.
So I for condonation of 110 days of delay, so notices my goal also.
But Mr. S.P. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of 110 days in preferring the connected MAC appeal. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice to the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order. Returnable on 31st of March.
Item 45.
Please, your lordship. I is for condonation of delay of 56 days. Lordship.
Same. What is your name?
N. Burman for A. Bhattacharya.
Heard Mr. N. Burman appearing for Mr. A. Bhattacharya, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of 56 days in preferring the connected MAC appeal. Stop. Issue notice to the respondent opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st March.
Item 46.
But 15 days delay in filing accompanying appeal.
Heard Mr. M. Khan, learned counsel for the applicant. This application has been filed by the applicants, claimants, praying for condonation of 18 days, condonation of the delay of 18 days in filing the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuing notice upon the opposite parties within 7 days from the date of this order, returnable on 31st of March, list accordingly.
Item 50 from supplementary list.
May I please, lordship. Lordship, matter it's for hearing.
It is ready.
Question number 3.
The appearance is complete. Have you verified? How many respondents are there?
Only one.
Only one. How he is respondent number 3, then how there?
There two as it strike out.
Perhaps struck off my lord.
Heard Mr. What is your name?
Dr. Arhak.
Dr. R. Hawk, learned counsel for the appellants. Also heard Mr. T. Kolita, learned counsel for the insurance company. It is submitted at bar that by which order it has been struck out? Okay. It is submitted at bar that it is submitted by learned counsel for the appellant that by order dated 25/7/2024, the names of respondent number 1 and 2 have already been strike out from this appeal. Hence, this appeal is ready for hearing. Learned counsel for the insurance company agrees to the said submission. List this matter when
26.
data tandiyo.
For hearing,
Yes, sir.
can it be in the next month, my lord? If possible, my lord.
7th of April,
Your Lordship, short date can be.
March on the
March.
26th March.
26th of
We have
March.
cases, fixed cases.
Because Lordship, they are in Borpeta court, the amount is not disbursed.
On 26th March, we'll hear and dispose it.
Okay. Published.
Much 51.
May I plead your lordship? Respondent two's notice is not served yet received. Notice received,
Not yet received.
not yet received, sir.
Yes, madam.
According to the office note
When have you taken steps?
28 to 2024.
24.
Yes, lordship.
You take fresh steps.
Hmm.
Heard, miss, what is your name?
P. Bordoloi
P. Bordole,
for K. Bhattacharya.
appearing for K. Bhattacharya. On perusal of the office note dated
16 to
16/2/2026, it appears that the notice upon the AD card issued along with the notice to respondent number 1 has been received back after due service. However, the notices issued to respondent number 2 has not yet been received. Stop. In view of the now on perusal of the AD card, it appears that the said AD card bears the signatures of respondent number 1. Hence, the notice issued to respondent number 1 is held to be duly served. As regards respondent number 2 is concerned, the appellant shall take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returning along 31st March.
Then 52.
Lordship, according to office note, respondent 1 and 2 were not found in the mentioned address. 2 weeks time may be granted to collect new address.
You are for?
Insurance, my respondent number 3, my lord.
3. Lord Miss P. Bordole, appearing for K. Bhattacharya, learned counsel for the appellant. Also heard Miss L. Sharma, learned counsel for the insurance company. On perusal of the office note dated 16/2/2026, it appears that the notice issued to respondent number 1 and 2 could not be duly served as the address mentioned in the notice could not be traced out. Stop. Learned counsel for the appellant prays for some time to find out correct address of the respondent number 1 and 2. The prayer is allowed. Let this matter be listed again on 31st March.
Okay.
List according.
Item 26.
Where is Central Government Council?
Already informed, physically informed.
At 2 PM he will come, Kulsi.
Let him come.
Yes, ma'am.
Item 49.
Ahmed, please, Your Lordship. Your Lordship, we have preferred an appeal that is in relation to the rejection of our Section 8 application under the Arbitration and Conciliation Act. Your Lordship, what has happened is that, and
Section 8.
yes, for referring the dispute for adjudication by way of arbitration. Section 37 provides for, Your Lordship, appeal. 37(1)(a).
Arbitration Act. Bare Act. Yes, you read out what is
Yeah,
there.
notwithstanding anything,
Yes.
notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders. 37(1)(a).
Okay. So. Okay, so appeal lies.
Yes.
Now what is,
Now, Your Lordship, this is a statutory appeal. It has come up for admission. I have a interlocutory application praying for the stay of the proceeding. Your Lordship, what has happened here is this.
why stay of the proceeding? Why it was rejected on what?
Yes, that, if Your Lordship may just take my interlocutory application, I've given the annexures.
Now, first we let us issue notice in the
Yes.
arbitration appeal. Heard Mr.
D. Senapati.
Mr. D. Senapati, learned counsel for the appellant. This appeal under section 37 within bracket 1
A.
within bracket small a of the Arbitration and Conciliation Act 1996 has been preferred by the appellant Messrs. Meghalaya Cement Limited, impugning the order dated
11/2/2026.
The court title you have not.
Court title in the appeal memo, appeal
11
index, Your Lordship may see. page
11/2/2026 passed in Ms. J case number 15/2022 in connection with title suit number 11/2022 by the Court of Learned Civil Judge Senior Division, Dhemaji, whereby the prayer for referring the dispute to the arbitration was rejected by the trial court. This appeal is admitted. Issue notice to the.
Respondent.
How many respondents are there?
Only one, Your Lordship.
Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable under on 30 March. Let the records of Ms. J case number 15/2022 along with scanned copy of the records of title suit number 11/2022 be called for from the trial court. The registry shall take steps for requisitioning the records list accordingly. Yes, what is your?
Your Lordship, this money's title suit was initiated by the defendant, respondent, for recovery of some amount from me against supply of cement. That cement was procured from, supplied in pursuance to a tender. Your Lordship may just refer to page 46 here. The tender condition, clause 15. May be seen. If Your Lordship, clause 15, arbitration. For any dispute or difference in connection with the contract, the clause number 53 of GCC of supplies.
No, which page number?
Page 46, 46.
Yes.
Clause number 15.
Yes.
Now, this was the NIT. The NIT starts at page 44. Then your Lordship will find the GCC, that relevant clause 53, at page 75. 75. Your Lordship, clause 53.3, arbitration in the top of the page 75.
Yes.
Except as otherwise provided in clause 36 herein above, all dispute or difference in respect of which the decision has not been final or conclusive arising between the contractor and the purchaser in relation to or in connection with the contract shall be referred to arbitration in the manner provided else hereunder. The fact that they have instituted a suit for recovery shows that the decision is not final. So arbitration will govern because this recovery is in pursuance to this NIT. There's no dispute on that. Paragraph 7 of their plain categorically says that it is in relation to the supply orders in pursuance to this NITs. The supply or now your Lordship may also see another clause here at the same page 75, court of competent jurisdiction.
Yes.
54. Any action taken for proceeding initiated on any of the terms of the agreement shall be only in the court of competent jurisdiction under the High Court of Assam at Gauhati. Now, with all due respect,
Where the suit has been filed?
This
money suit has been filed in which court? Dhemaji.
Dhemaji.
Okay.
It has been interpreted that it is within the jurisdiction of the Gauhati High Court, so that will have to compete it. That is not the dispute here. The dispute that is coming up, I will come to later. Just I'll refer to the terms provided first. Then page 81 may be seen, Your Lordship, the supply order. And relevant page is 83. Now, this supply order is dated 23/6/2009. Clause 12, Your Lordship may see. Any dispute arising out of the contract shall be referred to clause number 53 of general condition of contract for supply. Clause 53, I have already referred to. That is the general condition of contract. This is the supply order, clause 12. Then in the bottom, 14 and 15 may also be seen, Your Lordship. Any legal dispute arising out of this legal contract shall be subject to the jurisdiction of High Court of Gauhati.
then 15.
Why you are showing that 14 and 15?
Because in the impugn order, the Honorable Court has said that since the court jurisdiction clause has conferred jurisdiction upon a civil court, therefore that will have superior and the arbitration clause will not be applicable.
Now, where suit should have been filed according to you?
It is not a question of suit. Once the party have agreed on the forum of arbitration as
So
we
it should have been referred to arbitration.
arbitration.
Okay.
And the jurisdiction clause is with regard to any proceeding arising out of arbitration, like your lordship already knows the seat and venue. Like if I have to challenge the arbitration award.
Okay. What impugn order says? Why it was not?
Yes, your lordship may now come to the impugn order.
Where is that?
That is at page 35. Only one paragraph, small paragraph.
That's at 33.
It starts at 33. Relevant paragraph, para 5, page 35.
Just a minute.
May I read you? Peruse the
Yes.
paragraph 5. Peruse the materials on record. It appears parties have not entered into a separate arbitration agreement. That is absolutely not correct. GCC forms a part of the contract. There is an arbitration clause in the general condition of contract showing the manner. But the plaintiff is claiming that the general condition of contract does not relate to the agreement between the parties. Moreover, it appears from the supply order dated 5/5 that it is mentioned in clause 15.2 that any legal dispute arising out of this contract shall be subject to jurisdiction of High Court of Gauhati only. It is further mentioned that these conditions shall be read and construed along with the annexed general condition of contract for supply, and in case of any conflict or inconsistency between these two, the provision of this condition shall prevail. Therefore, it appears that the condition mentioned in clause 15.2 of the supply order prevails over the general condition of contract. In my humble submission, this observation is absolutely incorrect. There is, at the outset, there is no conflict between these two provisions. One talks about the agreed forum of dispute resolution. The other talks about the jurisdiction of the court in respect of any matters arising out of the arbitration proceeding.
The general condition of contract, GCC, is in respect of the NIT issued.
NIT issued governing all the supply orders.
Okay. And in the supply order also in clause 13, it was
is
mentioned.
What he has done.
Now, what do you want?
I would pray that considering if this, if it's your lordship, stay the proceeding out
No,
there.
why notice should be waived? What is the urgency?
The only thing is that your lordship, the court below has fixed it for final hearing. Now, if the matter proceeds.
Final hearing means evidence has been adduced.
Nothing. He just has ordered that final hearing, your lordship.
On Saturday.
On Saturday, 21st.
No, if it proceeds, do you
I feel
expect that court will dispose of the matter
no,
on?
it's a question of the moment it proceeds. If I submit my written statement or I submit to the jurisdiction, then there might be a waiver, kind of a waiver coming in here again. Because section 8, if your lordship says that it has to be filed prior to submission of the first statement of defense.
Or along with.
You have not,
I have not yet filed because it was kept in abeyance.
Written statement you have not.
Not filed. Because section 8, if your lordship goes back to section 8 of the Arbitration Act.
No, that you have complied with.
Hmm.
You have, before filing WS, you have filed section 8 petition.
And we moved an application for keeping in abeyance the filing of the written statement. That was allowed at that stage.
Heard. Now, under what provision this interlocutory application has?
I'm praying under 151 because in appeal, the Civil Procedure Code, because Arbitration Act does not provide for anything. But under 151, we also pray for stay of the enforcement of an award for release of deposit amount under 151 only, your lordship.
Heard. Mr. M. Senapati. M.
D.
D. Senapati. London. counsel for the applicant. This interlocutory application has been filed by the applicant under section 151 of the Code of Civil Procedure, praying for stay of proceedings, 151 of the Code of Civil Procedure, in connection with the arbitration appeal number 4/2026. In this by filing this interlocutory application, the applicant has prayed for stay of the proceedings of, is it title suit or money suit?
Title suit, Your Lordship.
Title suit number 11/2022, pending before the Court of Learned Civil Justice Senior Division, Dhemaji. Learned counsel for the petitioner has submitted that the respondent that is NHPC Limited has you supplied the cement.
Yes, Your Lordship. They have issued.
Why
NIT
they have filed suit?
For
What?
realizing some amount that they claim that I'm not entitled for because I have availed excise benefit. So they want to
Okay, so
recover that money.
refund. Illegally. NHPC. No, submitted that the present applicant is a private limited company and has had participated in a bid on the basis of NIT issued by the respondent for supply of cement
Yes, sir.
or supply of the cement. The respondent
Paragraph 5, Your Lordship.
that is National Hydropower Corporation within bracket NHPC had floated the aforesaid tender for procuring cement to be used in the construction activities of Subansiri Lower Hydroelectrical Project. Stop. After participating in the tender process, the respondent was issued, the applicant was given supply orders by the respondent for supply of cement, and accordingly the applicant made the supply and payments were made by the respondent to the applicant. However, The respondent thereafter instituted a suit before the Court of Learned Civil Judge Senior Division Dhemaji for recovery of an amount of rupees 1,90,19,669. What was their contention? This was excess payment.
That they are, and since we have availed excise duty, they are entitled to claim that excise duty paid by NSPC to us.
So, on the ground that since the plaintiff have availed excise duty
Benefit.
exemption, and the said excise duty has been paid by the respondent, they are entitled to recover the aforesaid amount. Stop. The aforesaid suit was registered as title suit number 11/2022. Learned counsel for the applicant submits that since in the general condition of contract as well as in the supply order, there was an arbitration clause for referring any dispute between the parties to an arbitrator. The applicant, before filing its written statement, preferred an application under Section 8 of the Arbitration and Conciliation Act 1996 for referring the dispute to the arbitrator. Learned counsel for the applicant has submitted that. Where is that GCC clause?
GCC is at page 58, relevant page, page 75. 75, 53.3, top of the page.
Learned counsel for the applicant has submitted that the general conditions of contract for supply contained in clause 53.3 an arbitration clause wherein there is clear stipulation of referring any dispute between the contractor and the purchaser in relation to the in respect of any decision which has not been made final or conclusive in connection with the contract to the arbitration in the manner provided in the said GCC document. He further submits that the supply order issued to the present applicant by the respondent also contained in clause 12 thereof an arbitration clause. However, when the applicant had filed the application under section 8 before the trial court. The trial court, no, he submits that the trial court erred in interpreting the arbitration clause and rejected the prayer by holding that the parties have not entered into separate arbitration agreement, which according to him is wrong, was wrong on the part of the trial court. Stop. He submits that the impugn order of the trial court, the said order of the trial court, whereby the application under section 8 of the Arbitration and Conciliation Act filed by the present applicant was dismissed, has been challenged in the connected appeal, and the connected appeal within bracket arbitration appeal number 4 of 2026. He submits that said appeal has already been admitted and notice is also issued to the respondent. He further submits that if the further proceeding of the title suit number
11 of 22.
11 of 2020 to 11 of 2022 is not stayed, it may amount, and if the applicant participates in the proceeding, it may amount to waiver of what?
Waiver of the present appeal and my contention as to
No,
the-
it may amount to the waiver of the contention raised by the applicant for referring the matter to arbitration, as well as if ultimately the appeal is allowed, and in the meanwhile, if the applicant is asked to participate in the aforesaid suit, he may also face prejudice if ultimately the matter is referred to and decided, may also face prejudice during the arbitration proceeding in the event of allowing of the appeal, as event of allowing of this appeal. Stop. By filing written statement, no, just a minute. And this is a query to you. If you file written statement in the suit, how you will suffer prejudice if
basically,
ultimately your appeal is allowed and matter is referred to arbitration?
first of all, they will get to know what my case is. Secondly,
Yes.
I will be,
It is not
Huh? and secondly, it is fixed for hearing according to my instructing counsel.
So,
And
so he also submits that since the title suit number 11/2022 has been fixed for final hearing by the trial court, if further proceeding is not stayed, the appeal, the connected appeal filed by the present applicant may become infructuous, even if even in the event of getting a favorable order by this court. Stop. Issue notice to the respondent. The applicant shall take steps by issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 30th of March. Stop. However, in the meanwhile, considering the submissions made by learned counsel for the applicant, as discussed in the foregoing paragraphs, further proceedings of title suit number 11/2022 pending before the Court of Learned Civil Justice Senior Division Dhemaji shall remain stayed till next returnable date. List accordingly.
Much objection.
Item 47.
Please, your lordship. Lordship, my learned senior is in another court, your lordship, and it would be personally difficult for him to pursue this case today. And so does for the opposite counsel, Mr. Anna.
He is also in other court.
Lordship allows this matter may be listed on 23rd.
23rd.
The execution case.
What is the matter?
It relates to stay of an execution case, your lordship.
I am ready now. Okay, we are adjourning. What is your name?
G.K. Roy, your lordship, on behalf of R. Sharma.
Heard Mr. G.K. Roy, learned counsel for the appellant. Also heard Miss
F. Sultana on behalf of
F. Sultana appearing
number 1.
on behalf of respondent number 1. Learned counsel for both parties have submitted that the conducting counsel for the appellant as well as respondent in this appeal are on legs in a different court, and therefore they pray for an adjournment of this adjournment in this case. Considering the submissions, the prayer is allowed. Let this matter be listed. 24th March.
So the execution case is pending on 24th of February in the trial court, your lordship. Lordship allows 24th of this month also. We're fine.
Okay, 24th of February.
It be obliged to lord.
Obliged.
Item 26.
Yes, what is this?
My lord. Yeah, we are the claimant in RCT, my lord, Railway Claim Tribunal. So the Railway Claim Tribunal passed the order which is reflected in page 23, my lord, last portion.
This is in orders column or admission?
No, this is an orders column. So this matter may come up for admission since the service is complete and record is also there.
My lord, prayer is though.
No, why admission? It is otherwise ready for hearing.
Exactly.
Yes.
We'll admit it today.
Yes. Lordship may admit it.
And we'll fix a date for hearing,
Yeah,
finally dispose it of.
Exactly.
Instead of.
No,
I am agree, but matter is very simple. Only one question is arises. My lord, we are not.
Are you ready for hearing today?
Only two. I am suffering from serious illness. My money was deposited in bank fixed deposit. Already 2 years passed. I pray before your worship to allow to withdraw my money fixed deposit for my.
Who is the
treatment.
appellant in this
This is case.
Claimant is the appellant.
Why this appeal?
Appeal is, he has filed an application because as per the provision of the act, the amount of compensation has been kept in the fixed deposit. So he filed an application for premature withdrawal of the
deposited.
premature.
Oh, that can be decided now.
Yes, premature withdrawal.
So the
That much, my lord.
the premature withdrawal, whether it is sustainable or not, the learned court below has come to a finding that they have not annexed material, sufficient materials to address the issue that has been made in the application. So this is the main thing. They are saying that they want to purchase the property, the land.
Premature withdrawal prayer was rejected by
Rejected.
the
Yes,
tribunal.
my lord. Only my part, my lord. Other part regarding my children, I am not prepared for to allow withdraw, my lord.
What was your ground?
My lord, ground, I am suffering from serious.
No, before why you sought for premature withdrawal?
Yes, that was, my lord. I am suffering serious illness along with we have no permanent domestic house. So earlier we have.
Where is your petition?
Petition.
Page 37, my lord.
To construct
Page
your
39. Page 39, I have filed before the original court, madam.
on where is the ground?
Ground is not.
My lord, ground is that page 43, my lord. 12.
You want to purchase a house?
My lord, it was purchased a house. Another thing is that now I am suffering serious ailments.
Where is the rejection order?
But that rejection order is page 74, my lord.
How much money is deposited?
On my lord, 3 lakhs, my lord.
In your name?
My lord. My lord, here two applicant. Applicant number one deposited 2 lakhs and applicant number 3 is the wife. Applicant number 2, my lord, 3 lakhs.
Okay, where was the tribunal wrong? What is the error?
My lord, here the tribunal finding is that we have failed to annex the Gauhati certificate regarding the erosion. So already that Gauhati certificate is annexed here with my lord that petition also. My lordship will find that it pays in 71 of my 71.
Now you are suffering from what ailment?
And according from my lord, I have filed an additional affidavit, my lord. Page additional affidavit page 89, 88 and 89, my lord, regarding my medical prescription.
Now, what is the ailment?
Ailment, my lord, I am suffering from severe blood, my lord, going non-stoply, so we need
Suffering from?
blood, my lord. Blood is going.
And there must be some name of the ailment.
My lord, that is been written in my lord. Heavy means falls from 1 year, my lord, page
Yeah,
1 year.
from here,
From here.
losing of blood from here.
Page 88, annexation 9, my lord.
It's
Additional
severe disorder
1 year.
for 1 year.
Yes, Mr. Chaudhary.
Lordship, in the order, it has been reflected. This, the Gauhati certificate, although he has annexed. The thing is that the medical condition that my learned friend is expressing is not so serious condition. And the learned tribunal, while rejecting the prayer of the appellant lordship, made a mention with regard to the provision and the guidelines of the Honorable Apex Court lordship. So now it's up to your lordship to take a call on that. Because they have admittedly, they have not annexed any document to substantiate their cause. The learned tribunal arrived at a finding that there is a direction of the Honorable Apex Court, because the plundering of the compensation amount is always there. So the apprehension taking into
Yes.
consideration the welfare of the claimant lordship, that order has been passed, not prejudicial to the interest of the claimant.
Here, my lord, it is a benevolent legislation. I know what is good for me, my lord. No doubt, if I waited for some days, my lord, I will be benefited. But at present, if the Honorable Court allowed me, no doubt I know well, I suffered monetary loss, my lord. Even my prayer is that, my lord. If I, my lord, die without treatment, my lord, thereafter, my lord, after measured what
Okay.
this
Lord,
money,
Mr. What is your name?
Mr. M. Hussain,
M. Hussain, learned counsel for the appellant. Also, Mr. S.P. Chaudhary, learned Central Government Council,
Yes, lordship,
appearing for the
for the railways.
railways. This appeal under section
23 of the RCT Act, my lord.
23 of the Railway Claims Tribunal Act 1987 has been filed by the appellants, namely Abdul Khalik and Ms. Mumtaz Begum, impugning the order dated 30/5/2025 passed by the learned passed by the Railway Claims Tribunal Gauhati bench in MA number 31/2025, arising out of OA2 number OA2U-78/2023, whereby the application filed by the present appellant for premature disbursement of their fixed deposits of the part of claim amount was rejected by the claims tribunal. Learned counsel for the applicants has submitted that what was the order?
Order was, my lord, page 76. My lord.
What was
Original order, my lord.
original order?
Original order, my lord, page 43, my lord, relevant portion.
Learned counsel for the appellant has submitted that
Page 20, my lord.
the present appellants, along with their minor daughters, had preferred a claims case
Relevant person, page 20, my lord.
claim case before the Railway Claims Tribunal due to accidental death.
Yes, my lord. Our son, my lord.
Accidental death of their son on 17/6/2019 near Bhawanipur Station Railway Crossing Gate number 36. The said claim filed by the applicants under Section 16 of the Railway Claims Tribunal Act 1987 was registered as original application, registered as OA Roman 2 small u dash 78/2023, and by its judgment dated 26/6/2024, the Railway Claims Tribunal Gauhati bench allowed the application and awarded the compensation
Page 20, my lord. Total 8 lakhs order.
to the extent of rupees 8 lakhs. In total, out of the total 8 lakhs in compensation amount of rupees 8 lakhs along with penalty interest at the rate of 6% per annum. Stop. Out of the total awarded amount, it was directed that rupees 3 lakh would be payable to present petitioner number 1 and rupees 3 lakhs payable to petitioner number 2, and remaining 2 lakh would be distributed equally amongst the daughters of the present petitioners, that is 1 lakh each. It was further directed by the Railway Claims Tribunal that out of the compensation amount of 3 lakhs awarded to the present petitioners, two lakhs shall be deposited
Only regarding appeal number 1, immediately 1 lakh allowed to withdraw for assistant help, the remaining 2 lakhs deposited in the FD for 1
deposited
year.
in fixed deposit for a period of 1 to 2 years, and 1 lakh would be deposited, would be disbursed, would be disbursed to the each petitioner. And in respect of no, 1 lakh to be disbursed to the petitioner number 1. Whereas in respect of petitioner number 2, the entire compensation amount payable to her was directed to be deposited in 3 separate FDRs of 1 lakh rupees each. So it will be 5 lakhs. How much amount?
5 lakhs. Now 5 lakhs. 2 lakhs for petitioner number 1 and 3 lakhs for petitioner number 2.
Stop.
2 lakhs extra.
As regards the minor daughters of the appellants are concerned, the compensation awarded to them were directed to be deposited in fixed deposit in a nationalized bank till the attainment of majority by them. Stop. Learned counsel for the appellants have submitted that since both the appellants are very poor, and since they don't have any house of their own, they file an application before the Railway Claims Tribunal for premature disbursement of the fixed deposit, disbursement of the claim amount which were deposited in fixed deposit in the name of present appellants. However, by the impugned order dated, where is the impugned order? Page?
39, my lord.
39 is the misapplication. Where is the impugn order?
Last page. 77, my lord. Last page, my lord, that's relevant person 74 starting.
Impugn order dated 35/2025. The Railway Claims Tribunal rejected the prayer of the appellants. Learned counsel for the appellant submits that the main ground for rejection of the prayer for premature encashment of the FDRs by the appellants was that they had failed to substantiate their claim by producing any document to that effect from the Gauhati, and that there are other welfare scheme operating in rural areas which they could have availed. Learned counsel for the petitioner's appellant submits that due to their ignorance and illiteracy, they could not submit the document before the Railway Claims Tribunal. However, you have produced the document here.
My lord.
Where is it?
Gauhati certificate, my lord, page 71, my lord.
However, they have submitted Gauhati certificate certifying that they don't have any house and landed property, and due to due to land erosion, their land has been submerged in Brahmaputra. Stop. He further submits that during pendency of this appeal, the appellant number 2 also suffered from gynecological ailments of severe bleeding during her menstruation period, for which they need money for better treatment. And in support of their submission, in support of his submission, the medical document in respect of ailments of respondent number 2 has been annexed.
Appellant number 2.
Appellant number 2 has been annexed as annexure, annexed
9.
as annexure 9 by filing additional affidavit before this court. Hence, they pray that their money, hence they pray that their the compensation amount which has been deposited in fixed deposit may be allowed to be disbursed prematurely, allowed to be encashed prematurely owing to the circumstances stated by the appellant. On the other hand, learned Mr. S.P. Chaudhary, learned Central Government Council appearing for Railways, has submitted that the direction for depositing the part of awarded amount in the fixed deposit was only for the benefit of the present appellant, as there are instances of unscrupulous elements taking away the compensation money
Yes.
which was awarded to the poor litigants. He further submits that the appellant also failed to produce any document before the Railway Claims Tribunal while they filed the before the Railway Claims Tribunal to substantiate their claim. That they are landless and have no house. He also submits that the nature of ailment with which the the appellant number 2 is suffering may not be so serious so as to require premature encashment of the fixed deposit FDRs. Stop. I have considered the submissions made by learned counsel for both sides. Though there is no dispute in the proposition that the direction of the Railway Claims Tribunal for depositing part of the awarded amount in fixed deposit FDRs was only for the benefit of the present appellants. Stop. However, the reasons shown by the appellants for praying for premature encashment of the FDRs also cannot be totally ignored. Though they fail to produce any document in support of their submissions before the Railway Claims Tribunal, however, before this court, they have produced the certificate from Gaumura regarding the fact of erosion of their land by river Brahmaputra. Additionally, the medical documents produced by the appellant, which shows that appellant number 2 is suffering from serious gynecological ailments. These facts, in the considered opinion of this court, are sufficient to allow premature disbursement of the FDRs in which the portion of their claim amount was directed to be deposited. Stop. In view of the aforesaid discussions and reasons stated, this appeal is allowed. And which FDR will be?
Respondent number 2, my lord, in the
FDR numbers?
of the FDN numbers, my lord. FDN, my lord, page 23, my lord. Page 23. My lord, it may be, my lord, in page 4, my lord, my statement in that. Page 4, it will remove.
Where is your application before the tribunal?
Application. Page 39 onwards.
Accordingly, the compensation amount of rupees 2 lakhs awarded to the appellant number 1, which was deposited in FDR in UCO Bank, bearing account number 13380110130,735 within bracket, bearing FDR number 13380310060,308 amounting to 1 lakh. Into ইয়াৰ পৰা লৈ ল'ব. Page number 37. Is allowed to be disbursed to the appellant number 2, appellant number 1 and 2 by the bank in which the same is deposited within a month from the date of this order. This appeal is accordingly allowed.
Highly obvious.
Possibly LCR is there, so it should be sent back to
The records of the Railway Claims Tribunal be sent back to the Railway Claims Tribunal along with a copy of this judgment.